paper. I think my paper is going to be listened in the hall. My topic is why uniform civil code is not a Panacea to our social-legal asymmetries. Before going to Article 44, I would like to discuss three articles. That is Article 343, Article 334, and Article 370. Because an Article 44, what is it for which I have connected these articles with Article 44 is that these all articles are ephemeral in nature. Article 343 which says that when Hindi is going to replace English as a lingua franca after 15 years, that is 26 January 1965, the Hindi is going to be the national language of India. And Article 334 which says that the reservation of the seats in the reservation of the seats for the presentation in the parliament assemblies under Article 334 and Article 370 are we ready for, and also these articles are having the abrogation and implementation of these articles is going to be done in a time limitations, and the society is ready for the implementation and abrogation of these articles. I think that this is not going to happen. And again, Article 44, which says that the state should endeavor. There is nothing like that. Time limitation is for this. Now I would like to move towards the church relationship and Indian state. What kind of secularism we have? We people have my preceding speakers have said more about the secularism in other countries, and specifically they have discussed about Turkey and France. I would like to discuss that the secularism which is being practiced in the France is based on the doctrine of laicite. Laicite, which means that the state has an attitude merely anti-religious. And also, you people have discussed about the Turkey model. And Turkey model, it was not on the democratic principles, but it was on the Kemalist ideology. It was not at all a democratic reformation in that. Now I would like to discuss about what kind of secularism. If you are going to accept this kind of secularism in Indian society, then I would like to say that it could be thought that such was not the intention of Constituent Assembly. And now I would like to discuss our Indian secularism is an accommodating towards religion, for which we have now incorporated Article 25 in our Constitution and also Section 7 in our Hindu Marriage Act of 1955 and Parsi Marriage and Divorce Act of 1935. In this regard, I would like to discuss about the contours of Article 25. What it says. I have quoted Vijay Manuel versus State of Kerala, a part of the judgment. What it says that the Article 25 is an article of faith in the Constitution. The real test of the democracy is an ability of even an insignificant minority to find its identity in the Constitution. The principle has to be borne in mind while interpreting Article 25. And now, with these three examples, it can be envisaged that what kind of secularism is being practiced in India. Indian secularism is not an aggressive model, but it is an accommodating one. And now I would like to move towards Article 371A, which defines that what kind of relationship is there between the Indian Union and Nagaland. What it says that no act of the Parliament concerning any of the following matters would apply to the Nagaland unless the state legislative assembly is so decided by the resolution. What are those following details are religious and customary practices of Naga and administration of civil and criminal justice regarding the decision according to the Naga customary laws. And again, I would like to discuss about Article 371F, which says that everyone knows that the state is not going to discriminate us regarding the reservation of seats on the religious grounds. But again, Article 71, which deals with Sikkim state, which says that out of 32 seats in the Legislative Assembly, Sikkim Legislative Assembly reserved the legislative seats for Budhia Lepchak and also one seat for the Sangha, who are the religious minority in the Sikkim region. And then I would like to discuss how from community to community and also from region to region the laws are different, for which I would like to discuss Dravida school of thought in Hinduism, which says that the Dravida school where marrying mother's brother is valid, but in any other school it is being outlawed because it is an incestuous marriage. Now I would like to raise a question regarding that. Is uniform civil code is the only way to reform personal laws? For which I would like to take you back to the historical or legal history of India, in which the dissolution of Muslim Marriage Act was adopted not under the Hanafi school of thought, but under the Hanbali school of thought, which is more favorable to the Muslim women. And can we have this kind of things? And also, I would like to discuss about the Shamimara versus Union of India. The triple talaq, all these issues have been outlawed under Shamimara versus state of UP. And also, the Muslim dissolution marriage of 1986 has been outlawed under Daniel Lafifi versus State Union of India. And then, in this regard, what the court has said, let me quote. Divorce shall not be valid unless preceded by an effort of reapportionment. That reapportionment means under 3 successive tours. Again, it is going to be the court has decided to have a Quranic principles of talaq. And then I would like to say the law making and implementation of law. This is the biggest question which we have. Okay, the law is not a mean to is the law is not an end, but is a mean to achieve the end. For which I would like to quote 2011 census chart 6, chart C3, where it says that about 43,56,294 Hindu women are begins relationship with Hindu men, unless, of course, it can be discussed, proof that they are mostly married and non-Hindu. Now I should say that who is the victim of the law? The law which is not recognizing the woman as even a married woman, or what kind of social status is going to be given to those 43 lakh women. Let me see. With this empirical fact, it would not wrong me to say that if the polygamy lack legal sanction, it frequently exists more or less illegal form of concubinage. To this problem, I should say that permissive legislation should be allowed. And we have discussed a lot about Goa Civil Code, and then Goa Civil Code I understood is in permissive legislation, because again the Goa Civil Code is applying uniformly to everyone, but again it entertains some kind of differences. What is that differences? Is that thus the right of qualified polygamy is granted to the Hindu men. They can have second wife in certain circumstances based on the code of the usage and custom, the genital Hindus. Again, in the certain circumstances are there. Again, the Goa Civil Code three types of marriages. What is that? Catholic marriages not governed under Catholic churches, and non-Catholic marriages. Will uniformity will it lead to the stark relation for which I would like to give? And then in the last, I would like to say that the wordings of Savigny, who was the founder of historical jurisprudence, what he said regarding the laws. Law is the product of the life of the people and the manifestation of their spirit. The source of law is not the general consciousness of the people and cannot be borrowed from outside, which he defined as